SchnitzelNinja.
Respondent's Pre-Trial Statement, Case Number FC2023-052114, in re the matter of Laura Owens, Petitioner, and Clayton Echard, Respondent, filed June 3, 2024. Evidentiary hearing scheduled for June 10, 2024 at 8:45 a.m. Respondent Defendant Clayton Echard hereby provides this pre-trial statement for the evidentiary hearing scheduled for June 10, 2024 at 8:45 a.m. This proceeding is not complicated, but it is clearly unique given the fraud and circus-style antics from petitioner, plaintiff Laura Owens. Laura, who seems unburdened by both science and societal expectation of truth, filed an improper establishment petition and order of protection predicated on faked medical records after being rejected by Clayton Echard. Laura's medical record, arts, and craft skills have been honed over a decade, wherein she falsified records to support fabricated twin pregnancies, forged ultrasounds, manufactured HCG reports, faked ovarian cancer, and feigned having an oophorectomy, ovary removal. She cannot claim that she lacked the intent to commit fraud upon this court when she filed these actions after oral sex, and then appeared in court twice, donning what appeared to be a fake moon bump. Laura's malignancy was exposed because she targeted Clayton, the former ABC bachelor, as her fourth mark. Clayton immediately disputed the pregnancy, causing Laura to utilize her playbook, alleging twins, crafting dating contracts, offering abortions, claiming suicidality, and alleging that she was the victim of sexual assault. Laura also contacted the media, footnote 1. In addition to Laura contacting The Sun, Page 6, and People, her counsel has made comments about looking forward to reading the obituaries of reporters and about making them homeless, ostensibly consistent with how Conor McGregor would act if he was litigating this case. End footnote. Which resulted in 3 prior victims of the same pregnancy connecting. What Laura failed to consider was that her claim of being 24 weeks pregnant with twins and vague miscarriage allegations, including suggesting that twins were reabsorbed into her body, would result in the media she contacted comparing her to known fraudsters like Scamanda. As if unable to stop, Laura continued to commit fraud, including misleading her own medical expert, who impressively and contrary to science appears to have determined paternity without DNA testing, by failing to tell him about her medical history, or faked history, including but not limited to ovarian cancer, an oophorectomy, as well as the fabrication of the sonogram he reviewed, and perhaps even the July 23 miscarriage photos. Laura's attempt to prevent a full and fair adjudication have only escalated as, through counsel, she, per witness Michael Maricini, suggested a witness would be arrested if he appeared at court for this trial. Further efforts to embarrass Mr. Maricini involved Laura's counsel posting a California deposition transcript from 2018 online. She, through counsel, even tweeted commentary about the case and this court. Footnote 2. Tweeting on or about May 26, 2024, that Clayton's counsel, quote, wanted to inflame and bias the judge, end quote, and it, quote, seemed to have worked, end quote. And footnote 2. As well as posted medical records contrary to the court's orders. She even mocked Dr. Dean's expertise and expert report, and then published it online. On May 28, 2024, Laura and her counsel published a joint blog post in which Laura made overt claims of suicidality and appears to admit the 2,500 pages of text with Maricini were legitimate, and that she never received an ultrasound for her alleged twin pregnancy. Days later, Laura, through counsel, posted parts of the video deposition of Clayton Echard on YouTube. Footnote 3. See the following link. Clayton implies he wanted to have sex, but Laura didn't. And the following link, taking pregnancy test at Clayton's apartment. End footnote 3. The level of inappropriate behavior in this matter is astounding. Laura's anticipated crocodile tears and claims to have been the victim of the media who exposed her cons are disingenuous. Laura's behavior should result in findings from the court in these 2 causes and may justify a referral to the Maricopa County attorney for charges of both perjury and evidence tampering. Background. 1. On August 1st, 2023, Laura initiated litigation when she filed her petition to establish paternity, legal decision-making, parenting time, and child support, alleging that she became pregnant with Respondent's twins on May 20th, 2023. 2. On August 8th, 2023, Laura filed a denied motion to communicate and, on August 23rd, 2023, a denied motion to compel. On August 29th, 2023, Laura filed a denied expedited consideration requested motion to communicate and, on September 14th, 2023, a denied expedited motion to seal court record. 3. On August 21st, 2023, Clayton, representing himself, filed his answer, denying any pregnancy with twins after only oral sex. Footnote 4. Laura's evolving tale regarding May 20th, 2023 has changed during the litigation and now includes a grape insinuation. In messages to Clayton in effort to force a dating contract, Laura acknowledges there was no intercourse and offered that her vagina is tight after not having sex in more than a year, but then claimed some of his fluids were down there and that I don't know the difference between types of cum. It was not until 2024 that she alleged she was raped, after first alleging that Clayton was too high to remember having intercourse, insinuating she had taken advantage of him. End footnote 4. See also Respondent's granted motion to leave to amend response filed December 12, 2023, and Respondent's amended response to petition to establish filed January 26, 2024. 4. On September 28, 2023, through an early resolution conference, parties entered a Rule 69 agreement stating, quote, petitioner agrees to contribute a sample on October 2, 2023 to determine paternity of the alleged pregnancy, end quote, testing to be conducted by RavGen. 5. On October 6, 2023, Laura filed for an ex parte order of protection, FC2023-052771, claiming that she was pregnant by Clayton and that he was cyberbullying her by posting her medical records online. That same day, the RavGen results came back indicating little to no fetal DNA, and Clayton thought the nightmare was over. He was very wrong. Number 6. On October 18, 2023, Laura filed a request for pre-decree meditation, denied. November 22, 2023, alleging Clayton would not speak with her and, quote, he even acts as if the unborn children don't exist, despite a preponderance of evidence, end quote. 7. On October 24, 2023, Laura appeared by video before Judge Cynthia Jalketsis, CV 2023-053952, wearing what appeared to be a fake pregnant stomach, moon belly. She was also photographed on September 27, 2023, competing in a horse jumping competition with a visibly flat stomach and was signed up to compete in late November 2023, but allegedly backed out after attempting to sign up under a different name. Emily Wilson. 8. On October 25, 2023, Laura appeared before Judge Duty, FC 2023-052771, again wearing what appears to be a moon belly, and testified as to the veracity of a sonogram of their son, which she has since claimed no knowledge of, but that she sent to both Clayton and the media, as well as including in her publicly accessible Dropbox on Reddit. See also Respondent's motion for relief from judgment filed March 26, 2024. 9. On November 2, 2023, the second day of trial on Clayton's granted injunction against harassment, Laura testified that she was, quote, 100%, end quote, and quote, 24 weeks, end quote, pregnant by Clayton, and that she was due, quote, February 14, 2024, end quote. Laura further specifically detailed she was experiencing a high-risk pregnancy due to her alleged epilepsy, and that she was being seen by specialist Dr. McCool and Dr. Higley, and that she had had an appointment with Dr. Higley last Friday. After this court ordered Laura to comply with disclosure, she had refused to comply with Rule 49. It was confirmed that Laura's testimony was false, and she was never treated by doctors McCool, Higley, or any obstetrician or gynecologist during her alleged high-risk pregnancy with twins. Footnote 5. Laura self-reported to her neurologist via video while in the seated position that she was 21 weeks pregnant with twins. Laura also told the provider that she saw for the first time on November 14, 2023, MomDoc, that she had been pregnant, that the pregnancy had been confirmed by Planned Parenthood, that she passed 2 sacs, and that she had been told that her blood HCG levels were not consistent with a viable pregnancy. There was no sonogram at Planned Parenthood, and if the latter statement bears any truth, this means Laura was told she was not pregnant before she testified in front of Judges Judy Jalketsis and this court. End footnote 5. 10. On December 6, 2023, results of yet another RAV-Gen test again confirmed little to no fetal DNA. Again, Clayton thought the nightmare was over. He was wrong again. Note the second RAV-Gen test was allegedly lost in transit. 11. On December 12, 2023, Clayton filed a notice of filing affidavit of non-paternity, avowing that he could not be the father to any children from Laura as they never had sexual intercourse. Clayton also filed his granted expedited motion to extend dismissal date on inactive calendar and schedule an evidentiary hearing. 12. On December 28, 2023, Laura filed her denied, footnote 6, although the court's minute entry dated January 25, 2024 does suggest that Laura's motion to dismiss was granted but maintained as, quote, the issue of sanctions and attorney's fees remain, end quote. The court's minute entry dated February 21, 2024, and discussion in court clarifies that the court was denying petitioner's motion to dismiss petition to establish. End footnote 6. Motion to dismiss petition to establish paternity, legal decision-making, parenting time and child support with prejudice, as well as notice requiring strict compliance with Arizona Rules of Evidence, which invoked Rule 2A, Arizona Rules of Family Law Procedure. For the first time, Laura's motion cryptically claimed that she, quote, is not now pregnant, end quote. 13. That same day, Clayton notified Laura of his intent to dispose her pursuant to Rule 57A1 and requested the production of documents pursuant to Rule 62. 14. On January 2, 2024, Laura filed a denied expedited motion to quash deposition of petitioner. Laura's counsel, her first of 3 attorneys, withdrew. 15. On January 3, 2024, Clayton filed a response objection to petitioner's motion to dismiss, footnote 7. For brevity, this background summary excludes all other response and replies filed in this matter, end footnote 7, as well as a withdrawn motion for sanctions pursuant to Rule 26. 16. On January 17, 2024, Clayton filed a notice of non-appearance at deposition pursuant to Rule 57G, notifying the court that Laura willfully failed to appear at her deposition and requesting attorney's fees pursuant to Rule 57G. 17. On January 18, 2024, Laura, with her second counsel, filed a denied motion for confidentiality and preliminary protective order claiming for the first time that Laura had a miscarriage. Notably, no other information about the alleged miscarriage was provided. 18. On February 2, 2024, Clayton was deposed by Laura. Footnote 8. Pursuant to Rule 59C2, Clayton intends on offering this deposition against Laura, including discussion of the ultrasound Laura had admitted to altering and presented as an exhibit, as well as the ultrasound video on pages 42 to 44, 46, 63, 90 to 91, 111 to 122. End footnote 8. 19. On February 6, 2024, Respondent filed a granted expedited motion to continue trial and motion for additional trial time. 20. On February 12, 2024, Respondent filed a granted expedited motion to set virtual status conference. The court scheduled an in-person status conference for 2/21/24. 21. At the conference on February 21st, 2024, this court addressed petitioner's failure to comply with Rule 49, see attorney's fees below. Petitioner claimed that she had a miscarriage sometime in September or October. The court indicated it would hear evidence and testimony as it applies to all pleadings filed within the Maricopa County Superior Court, and it would be viewing the order of harassment hearings. 22. On March 1st, 2024, Laura was deposed, and it was discovered that there was yet another pregnancy fraud allegation, number 4, from 2014 in San Francisco. Clayton intends to offer the entire deposition, footnote 9, specifically pages 1 to 175. Line numbers would be unhelpful as parts of the entire deposition will be utilized as evidence against Laura. End footnote 9. As evidence against Laura consistent with Rule 59C2. 23. On March 11th, 2024, Respondent filed a granted motion to compel. On March 12th, 2024, petitioner's third attorney withdrew. 24. On March 25th, 2024, Respondent filed a granted motion for joint hearing and granted in part, footnote 10. In the court's minute entry dated 5/22/24, the court clarified that it would be viewing the order of protection hearing before Judge Duty and deferring ruling on the motion pending the trial. End footnote 10. Motion for relief from judgment, which was amended on April 26, 2024. 25. On April 1st, 2024, petitioner's third attorney filed a denied motion for extension of time to respond to Respondent's motion to compel and a declaration of David S. Gingras in support of petitioner Laura Owens' motion for extension of time to respond to Respondent's motion to compel. 26. On April 3rd, 2024, Respondent filed a granted motion to withdraw motion for sanctions pursuant to Rule 26. Petitioner filed a notice of non-objection on April 4th, 2024. 27. On April 8th, 2024, petitioner filed a denied motion to compel lunch and for alternative relief. 28. On April 12th, 2024, petitioner filed a granted request for judicial notice, requesting this court take notice of petitioner's case against Greg Gillespie. Footnote 11. Mr. Gillespie is expected to testify that he experienced twin pregnancy fraud by Laura after rejecting her, and as addressed by Judges Bacchus and Gordon, and which involved a fake sonogram. End footnote 11. 29. On April 30th, 2024, petitioner filed a denied emergency motion to strike and request for immediate telephonic scheduling conference and denied motion in limine, attempting to preclude testimony from the 3 men who are anticipated to testify that Laura fabricated pregnancies, medical records, cancer, oophorectomies to force unrequited relationships. 30. On May 10th, 2024, petitioner filed a denied motion for judgment on the pleadings and renewed motion to dismiss, and on May 13th, 2024, a notice of non-availability and notice of errata. 31. On May 21st, 2024, Respondent filed a stipulated motion for virtual appearance of witness, Dr. Deans, MD, MPH. 2. Contested issues. 1. Non-paternity. This court should find that Clayton was not responsible for any alleged pregnancy. That Laura will claim she believed she was pregnant from oral sex is farcical and not the legal standard. Even if that was the standard, it is indisputable that Laura did not have any bias to believe she was pregnant with twins, as she alleged in her petition because she faked the sonogram records. She never sought obstetric gynecological care. She never had an ultrasound, and she lied to the court about her high-risk pregnancy with twins. Footnote 12. Before Judge Jalketsis on November 2nd, 2023, Laura testified to having a high-risk pregnancy with boy and girl twins being 100% and 24 weeks pregnant, and to being seen by doctors Higley and McCool. Laura admitted, as an exhibit a screenshot of her making an appointment with Dr. McCool. Laura has since testified that she never received care from any pregnancy provider or specialist. End footnote 12. Alleged pregnancy. Pregnancy is caused by sex, not relationship cons. Laura and Clayton did not have penile vaginal sex. Laura's allegations about what happened that night have morphed over time in order to fit Laura's narrative as she is confronted with science and the significant holes in her story. Laura has claimed there were fluids down there, then claimed that Clayton was too high to remember having intercourse, and then claimed Clayton raped her. Footnote 13. Curiously, in her underlying petition to establish, Laura stated there was no domestic violence and requested joint legal decision-making and a holiday schedule, as the sexual assault allegation did not arise until after Laura realized Clayton, like others, had zero interest in a relationship and that he was questioning her twin pregnancy narrative. End footnote 13. Laura even sent an email admitting they did not have sex and essentially begging Clayton to have sex with her for the first time because she was quote-unquote tight and had not had sex in years. Footnote 14. Note, with Gillespie, Laura also claimed she had not had sex in years. She later, with Gillespie, concocted a disturbing story that Gillespie and his counsel, undersigned, were involved in her kidnapping and rape, and that it was being investigated by the FBI in an ex parte letter to Judge Bacchus. End footnote 14. Laura's only proof of pregnancy is 1 urine HCG, footnote 15. HCG tests are not dispositive of pregnancy. As Dr. Deans will confirm, HCG can be present in an individual for reasons unrelated to pregnancy, including medications for epilepsy and fertility treatment, as well as if the person injects themselves with HCG. End footnote 15. Test conducted at Banner on June 1, 2023. 1 blood HCG test on October 16, 2023 that indicated levels of HCG that, by Laura's own admission, are inconsistent with a pregnancy. Footnote 16. Laura also alleges that she, quote-unquote, lost 30 pounds, and that is somehow proof of pregnancy, or that her body absorbed 24 to 28 weeks fetuses, all while competing in horse jumping competitions. Per her records on June 1, 2023, Laura weighed 121.25 pounds. On November 14th, she weighed 133 pounds. End footnote 16. Note, even her October 16th, 2023 HCG test provided to her expert is dubious, as Laura, through counsel, has admitted to sending an altered version with 102,000 HCG, 1,000 times higher levels, to the media. Laura again fabricated a medical record while simultaneously refusing to cooperate with Rule 49 disclosure obligations, resulting in the order to compel. Laura is guilty of both copious perjury and evidence tampering, warranting this court endorsing the Maricopa County Attorney's Office. Alleged sonograms. Laura faked the sonograms, or at least 3, with Clayton. There are no verifiable and requisite sonograms to support Laura's claim of being pregnant with boy and girl twins after oral sex. Footnote 17. Per Dr. Deans, an ultrasound provider may be able to determine a possible twin gestation, not gender, no earlier than 7 weeks gestation during an ultrasound. The only sonogram Laura states is hers indicates a gestational age of 6 weeks, 4 days. Parenthetically, the gestational age on the doctored sonogram, if obtained on 7/2/23, would be considered with a conception date of June 2nd, 2023, not May 20th, 2023. Sexes would not be discernible until around 16 weeks. Laura texted Clayton, quote, "We are having a boy and a girl, and I have an ultrasound to show you, and they dated it literally exactly to when we were together," end quote. End footnote 17. On 10/25/23, Laura testified before Judge Duty to getting a sonogram of their quote-unquote son. and providing it to Clayton because she was concerned about the baby's profile, whom she accused of using it to make an online Halloween meme, which he vehemently denies. Laura also admitted an exhibit, note 18. Laura's Exhibit 6, an email from Laura to Clayton, was admitted during the Order of Protection hearing before Judge Duty, FC2023-052171, end footnote 18, where she tells Clayton that she has a sonogram video dated 9/5/23. On 2/2/24, Laura used the doctored sonogram as an exhibit during her deposition of Clayton. On 3/1/24, Laura testified to obtaining the sonogram anonymously. Footnote 19. Planned Parenthood confirmed they do not offer anonymous appointments. End footnote 19. At Planned Parenthood, Mission Viejo, on July 7, 2023, and falsely and illegally attributing it to Southwest Medical Imaging, SMILE, and that she, quote-unquote, found out she was pregnant with twins in July. On or about 4/15/24, Laura then claimed the appointment date was July 2nd, 2023, and that she was seen at the Planned Parenthood in Costa Mesa. Both SMILE and Planned Parenthood have confirmed Laura was never seen there for an ultrasound. Planned Parenthood further confirmed that the alleged July sonogram is not consistent with ultrasound images generated by their practice. Still, Laura signed an affidavit for her expert that included the fake sonogram and stated, quote, "This image was taken at Planned Parenthood," end quote, emphasis in original. No evidence supports Laura ever being seen by a provider for an ultrasound, as this court noted in its 5/22/24 minute entry stating, quote, "Neither Planned Parenthood in Mission Viejo nor SMILE have any records for any ultrasound appointment for plaintiff," end quote. Alleged miscarriage. Laura was never pregnant by Clayton, could not have miscarried Clayton's twins. Laura's miscarriage tale, now apparently dated July 23rd, only arose after she was confronted by Clayton's desire to prevent her from getting away with her extreme pregnancy fraud con and exploiting another TEDx talk or chicken soup essay. This included Clayton notifying Laura he had contacted the Punitive Father Registry to prevent Laura from claiming she put the twins up for pretend adoption as a means of explaining their non-existence, all after testifying she was 24 weeks, actively being seen for high-risk pregnancy and due in February. Meanwhile, Laura continued to post on Reddit, published various blogs on Medium.com portraying herself as a victim, and contacting the media to advance her fictitious narrative. This is not the first time Laura has feigned a miscarriage or leveraged offers to terminate a pregnancy in exchange for the victim agreeing to date her. With Michael Maricini in 2016, footnote 20, Clayton disclosed 2,500 pages of text messages between Michael Maricini and Laura. In light of Laura's repeated claims that her victims, including Michael, have fabricated or tampered with communications, a computer forensic expert, Mr. John Berryhill, assessed the metadata and confirmed that there was no tampering. This confirmed that Laura historically claimed she had. End footnote 20. Laura alleged she was pregnant with his twins, that she believed she had a miscarriage, and that after speaking with providers, she knew, quote, what to look for to determine whether she was miscarrying, end quote. With Gillespie, it was offering to abort the twins if he agreed to date her. With Clayton, Laura alleged for the first time that she miscarried when she requested a protective order on 1/18/24. On 11/14/23, Laura self-reported to MomDoc, a provider she had never seen before, that she, quote, passed 2 sacs which appeared to have membrane but denies having much bleeding, end quote. During the status conference on 2/21/24, Laura told this court she miscarried sometime in September or October 2023. Footnote 21. Laura also was engaging in repeated communication with Clayton and the media, referring to sonograms and videos that showed she was quote-unquote still pregnant, in addition to testifying before 2 judges in late October, early November, to being quote 100% end quote, and quote 24 weeks pregnant end quote. And footnote 21. Days later, at her deposition on 3/1/24, Laura testified that in September or October, she passed 2 sacs that were less than the size of her hand, that she took a picture of them and sent it to an online provider. Footnote 22. There is no record indicating Laura showed any provider these alleged 2 sacs. End footnote 22. On 4/8/24, Laura, via counsel, stated she passed the 2 sacs on July 23rd, 2023, before Laura filed the underlying petition, her OOP, and before she testified before 3 different judges about her feigned pregnancy. Clayton's experts have reviewed the images, which may be fake, but even assuming they are real, and Dr. Deans will testify that, quote, there is no obvious embryonic or fetal tissue, end quote, which is complicated by the theory that Laura would have been miscarrying twins that were 8 to 11 weeks and would have experienced significant bleeding. Note, Laura refused to provide her phone to a forensic expert to confirm the image's authenticity, which is highly dubious given her admitted history of fabricating records. 2. Order of protection. The OOP against Echard must be dismissed because it was procured through intrinsic and extrinsic fraud by Laura. Clayton's positions are well summarized by this court in its 5/22/24 ruling and fully briefed in the motion for relief. The order was upheld by Judge Duty, who did not know the history of fraud, as a result of extrinsic and intrinsic fraud by Laura because she was never pregnant with his twins, and the ultrasound in the image Judge Duty found to uphold the order of protection was manufactured by Laura, who has since denied the image belongs to her despite sending it to Clayton and the media and including it in her public Dropbox on Reddit. 3. Attorney's fees, sanctions, and referrals. This court has broad authority to assess the conduct of Owens throughout the 3 proceedings before the 3 different judges and to sanction Laura pursuant to A.R.S. 25-324, 25-415, and 25-809G. Laura ignored disclosure obligations for nearly 7 months, and it was not until this court compelled her cooperation that evidence of a 4th victim was revealed, or that she committed to her recent tale of miscarriage in July. But despite allegedly passing 2 fetuses less than the size of her hand, she allegedly did not know she had miscarried until November, and curiously did not inform Clayton or this court until January. Laura's conduct cannot be accurately captured in the word unreasonable, as faking a twin pregnancy after oral sex, doctoring and submitting medical records, threatening witnesses, and committing continuous perjury deserves a word more befitting behavior beyond even the family court pale. Laura's conduct can be accurately captured in the word unreasonable, as faking a twin pregnancy after oral sex, doctoring and submitting medical records, threatening witnesses, and committing continuous perjury deserves a word more befitting behavior beyond even the family court pale. In addition to the fraud underpinning the entire litigation, the court merely needs to read Laura's Medium articles, the tweets, and blog posts to appreciate the scope of damage she has caused, which, as recent as May 28, 2024, includes a joint blog post from Laura and her counsel and YouTube postings of Clayton's video deposition. Clayton is entitled to all his reasonable fees and costs incurred pursuant to A.R.S. 25-324. To date, Laura has provided no evidence to support that she was ever pregnant by Clayton and with Clayton's twins. Laura has refused every opportunity to resolve the matter outside of court, and all efforts to comply with disclosure, including failing to appear at a scheduled deposition and not fully complying with the eventual order to compel. Recall, this entire saga was initiated by Laura going to the Sun and making false claims of pregnancy, ostensibly because Clayton rejected her. Laura's order of protection and the underlying petition were both filed in bad faith, as Laura knew that she was not and could not have been pregnant with Clayton's twins. Laura then proceeded to fabricate evidence, not for the first time. Footnote 23. As witnesses Maricini and Gillespie are expected to testify, Laura fabricated medical records, including sonograms, in her pregnancy con with their fake twins. End footnote 23. Testify before 3 judges to being 100% and 24 weeks pregnant with twins. Footnote 24. At the same time as her claimed high-risk pregnancy, Laura was actively participating in horse jumping competitions with a visibly flat stomach, contrary to her very visible moon belly. End footnote 24. And file irrational and legally unsupported filings that continued to assert what Laura cannot prove, that she was pregnant with Clayton's twins. And it was more than just simple misstatements, as this is extrinsic and intrinsic fraud upon the court, encompassing false testimony, altering evidence, and using coercive threats to tamper with potential witnesses and extort Clayton. Laura, the day before her deposition on March 1st, sent Clayton a letter threatening to sue him for a collateral allegation for around $1.4 million unless he agreed to dismiss this action. This overt, extortive effort is eerily similar to Laura's antics with Judge Backus in the Gillespie matter, where she maliciously claimed Gillespie and his counsel were involved in her rape in an attempt to avoid a hearing. Through her third counsel in this matter, Laura has intimidated witnesses, including suggesting Maricini would be arrested if he appears to testify, filed legally unsound filings designed to waste fees and delay trial, sent overt threats and harassing communications to Clayton's counsel and members of the media, engaged in toxic and inappropriate diatribe regarding this case through Twitter and blog posts, including using derogatory terms, insinuating that any ruling in Clayton's favor would be a mistake, and that the judge was biased against Laura, and appeared to intimidate Laura's own prior counsel into refraining from complying with his Rule 3.3 ethical obligations. 3. Witnesses. Respondent's witnesses. 1. Clayton Echard will testify to all issues. 2. Laura Owens will testify to all issues. 3. Michael Maricini, former romantic partner of Laura. See response to motion in limine. He is expected to testify regarding the origin of the 2,500 pages of messages with Laura from 2016-2017, where she made nearly identical claims involving fake twins, miscarriages, abortions, threatened suicidality, including claiming to be admitted into a mental hospital. He is expected to also testify regarding the personal claims in Laura's recent affidavit claiming he faked her medical records, which have been disproven by the forensic technology expert who verified that the medical records indicating ovarian cancer, ovary removal, were sent to him by Laura. 4. Greg Gillespie, former romantic partner of Laura. See response to motion in limine. He is expected to testify that Laura fabricated being pregnant with twins, claimed she had an abortion several times, and repeatedly stated she would dismiss her lawsuit if he agreed to date her. Gillespie is expected to confirm that the sonogram of twins sent to him by Laura was from Fiverr. He is also expected to testify in response to Laura's allegations that he doctored her medical records. 5. Dr. Samantha Deans, MD and PH, will testify regarding her expert review of the medical records of Miss Owens, including her analysis that the alleged HCG tests were never dispositive of pregnancy, and that the related miscarriage timeline, which includes detailed analysis of the likely origin of the HCG in petitioner's blood and urine, is not indicative of human gestational norms. Her testimony will also address the veracity of petitioner's miscarriage of 2 fetal sacs and alleged sonogram from Planned Parenthood. 6. John A. Berryhill, a forensic data expert, will testify regarding his expert review of the personal computer of Michael Maricini, including his analysis of the metadata, which confirms that no text messages or images sent by either party were altered or otherwise fabricated. 7. Any and all witnesses listed by petitioner subject to appropriate objection. Respondent's objection to petitioner's witnesses. Respondent objects to any and all of petitioner's witnesses which have not been timely disclosed. Respondent specifically objects to the expert testimony of Dr. Medhill under Rules 702 and 703, Arizona, as he relied on an admittedly tampered-with data set, made inappropriate conclusions regarding his beliefs unrelated to science, and appears to have concluded with zero scientific DNA basis that Clayton was the father of twins. His testimony is not the product of reliable principles and methods, or based on sufficient facts or data, and his opinion does not reflect a reliable application of the principles and methods to the facts of the case, and should not be precluded or given the weight it deserves. 4. Exhibits. Respondent's exhibits. 1. Text from petitioner re unblocking. 2. Text between parties re blocking and meeting up. 3. Messages between the parties. 4. LinkedIn messages between the parties dated 5/17/23. 5. Text messages between the parties dated 5/25/23. 6. Emails between the parties dated 6/28/23. 7. Email from petitioner dated 7/1/23. 8. Emails between the parties dated 9/17/23. 9. Email from petitioner re sonogram dated 10/14/23. 10. Email from petitioner to respondent's father. 11. Email from petitioner re ultrasound dated 10/6/23. 12. Text from petitioner re unblocking. 13. Email from petitioner re going public. 14. Article petitioner wrote, quote, "I am the anonymous woman in the Clayton Echard scandal. Here is my story," end quote, dated 9/22/23. 15. Articles where petitioner spoke to the press. 16. Article petitioner wrote, quote, "Unveiling the unbearable, my battle against cyberbullying and online harassment," end quote. 17. Petitioner's medical documents. 18. Petitioner's email to Hope re respondent speaking dated 8/3/23. 19. Emails from petitioner's mother to respondent. 20. Email from petitioner re threatening to sue dated 9/21/23. 21. Email from petitioner re medical documents. 22. Text messages between petitioner and Greg Gillespie dated 7/11/21 to 8/24/21. 23. Text messages between petitioner and Greg Gillespie re ultrasound dated 8/6/21. 24. Records produced by Family Planning Associates in response to HIPAA release. 25. Audio of Greg Gillespie and Laura Owens re being pregnant with twins. 26. Audio of Greg and Laura conversation re fabricated sonogram from August 2021. 27. Petitioner's affidavit dated 5/3/24. 28. Petitioner's sonogram dated 7/7/23. 29. Planned Parenthood response to follow-up letter dated 4/26/24. 30. Emails between respondent's attorney and Stormy Mitchell dated 4/26/24. 31. Petitioner faking ultrasound. 32. FTR for October 2023 hearing part 1. 33. FTR for October 2023 hearing part 2. 34. FTR for November 2023 hearing part 1. 35. FTR for November 2023 hearing part 2. 36. Records produced by Dr. Hunter and any lab test now in response to HIPAA release. 37. Records produced by Dr. McCool and Scottsdale Prenatal Associates in response to a HIPAA release. 38. Records produced by Barrow Neurological Institute in response to HIPAA release. 39. Samantha J. Deans, MD, MPH, Curriculum Vitae. 40. Faye Elizabeth Justitia Lind, MD, Curriculum Vitae. 41. Samantha J. Deans, MD, MPH, and Faye Elizabeth Justitia Lind, MD Expert Report. 42. Email to Steve Carbone, dated 4/24/24. 43. Email from Steve Carbone, dated 4/29/24. 44. Email to Dave Neal, dated 4/25/24. 45. Email from Michael Maricini, dated 4/26/24, including medical records sent from Laura Owens in 2016. 46. Twitter posts from David S. Gingras. 47. Berry Hill Expert Report, dated 5/7/24. 48. Berry Hill Digital Forensics Report, selected text messages. 49. Petitioner's deposition. 50. Respondent's deposition. 51. Petitioner's counsel's blog posts. 52. Petitioner's email to the court, dated 8/1/22. 53. Petitioner's counsel's emails and tweets. 54. Email between petitioner, current, and former counsel. 55. Notice of intent to sue. 56. Petitioner's MomDoc records. 57. Email from petitioner re suicide, dated 9/21/23. 58. Email from petitioner to Scottsdale PD, dated 7/21/23. 59. Medical records from Women's Care of AZ, Dr. Higley. Respondent and his counsel deserve the right to supplement this list of exhibits as necessary. Respondent's objections to petitioner's exhibits. Respondent objects to petitioner's expert's report under Rule 703, Arizona. Petitioner submitted admittedly falsified medical records to her expert for this review, including the sonogram that she has admitted to tampering and which has been confirmed not to have originated at Planned Parenthood or Smile, and notably not including the ovary removal she allegedly had in 2016, which she appears to be claiming she does not remember fabricating. Her expert relied on fabricated data to reach his conclusion, which itself is inadmissible under 702, meaning his written opinion is not based on, quote, those kinds of facts or data, end quote, and that experts in his field would, quote, reasonably rely on, end quote. Respondent objects to any and all of petitioner's exhibits which have not been timely disclosed. Respondent objects to any and all of petitioner's exhibits which have been doctored in any way, including those already admitted to being fabricated by petitioner, and which were confirmed not to have originated from any source petitioner testified to being seen by. Respondent further objects to any of petitioner's exhibits which are not relevant, cumulative, or lack foundation to these proceedings. Respondent is unable to prepare specific objections as petitioner has not disclosed her list of exhibits. Respectfully submitted on this 3rd day of June, 2024. Greg Woodneck. Verification. I, Clayton Echard, declare under penalty of perjury that I am the respondent in the above captioned matter, that I have read the foregoing respondent's pretrial statement, and I know of the contents thereof, that the foregoing is true and correct according to the best of my knowledge, information, and belief, and as to those things stated upon information and belief, I believe them to be true. Clayton Echard.
SchnitzelNinja!